teens are accused of killing their Spanish about it.
Very humble, and I just don't know why anybody would want to hurt her.
Her name was police say her body was found in Fairfield, Iowa, where she was known to take afternoon walks. According to the criminal complaint filed with the person Graber and repeated trauma to the head. The suspects, two 16-year-old students at Fairfield High School, where Graber and they found crucial meaning the motive, the planning and execution, and even deliberate attempts to conceal the crime. Both have been charged with homicide in the first degree and conspiracy to commit, tried as adults. We reached out to their legal representation. One declined to comment, and the said I speak to this particular case, but most cases path investigation discovery that the family of their client conveys sympathy to the family of Nohema Graber. In a statement, in her 9 years with Fairfield High School, Mrs. Graber touched the lives of many students, parents, and staff. As a community, we will remain united in this time of tragedy. Such a strong and beautiful woman as my mother.
Issa joins us. Is
right, Alice and her son
we appreciate it, Issa Gutierrez.
Hours away from Des Moines. Two students at Fairfield High School are charged. From Fairfield
was a tearful gathering, and even though so many people shared so many that's Fred Huck. He's a teacher who works here at Fairfield high school, and you work way uh, from great
Ay, mijita, claro que tú puedes. That translates to, oh, darling.
misty on Sunday afternoon. Her body was found in a nearby park under a tarp. A pastor who was here tonight offering these encouraging words to folks who are
praying with one another over those things. Those are going to be some of the things that's going to be important to do.
and folks who come tonight to a memorial where you can see the word, but we love you tonight to sign this memorial. And we should mention that a GoFundMe has been set up to help the family. So far, in the past few days, it's already raised more than $28,000. If you want to link to that GoFundMe, you can find it on our website, weareiowa.com. For now,
Current and former students were among those who got together to share memories and express shock.
It was in reality probably one of the best teachers we had because she held you to her standards, and that was good for her.
He's one of several students we talked with who great student charged for murder. Jerry Good.
Aiden, having him in my math class, he did speak not in a murderous way, but in a very aggressive way for dislike towards Miss Graber.
A couple of students told police say that same student went to Chautauqua Park, where Graber was known to go for walks. Her body was found covered
and her friends and how much she loved
the accused killers. Not saying what they know about the motive, and right here
there be a vigil for the throw.
Avenue here on the east side to set up you can visit. People will use it to write messages for no they tell me for their children who came home this week. Well,
year.
Not all of us liked Spanish 2 or 3. It was a hard class, but she was in reality probably one of the best teachers we had.
Murder. Jeremy Goodale and Willard Miller, who goes by his middle name, Chaden.
Having known Graber.
A couple of students at the school told us they heard it right up in Graber's class. Not long after that, police say that same student went to Chautauqua Park, where Graber was known to go for walks. In the same Spanish class as one of the accused killers.
I just wanted to teach you see how they're because
Just send for the teacher, and for more on that, let's throw it over to Kayla James.
Yeah, Andrew, entering here on the east side of the set up unit to write for Nohema Graber, who's so loved. They have pictures, doesn't lighten or hey, they just want people to come together during this time of grief. Both students and
Are you able to hear me? Is anyone able to hear me? Yay, I fixed it. Woo! Thank you, Punksy. Thank you, Nicole. Okay. Hopefully you should be able to hear the video too. So we will try that again. Just give me 1 second. This is so not how I imagined this first one going. So I apologize. So we will do this. But I hope everybody is okay and doing good. I need to go back a video or two, so hold on. We are here. Baby girl, shush. That's my dog, sorry. Baby girl. Shush.
Wheelbarrow and rail road ties and appear investigators say they found incriminating social media connections between them, detailing the motive, the planning, and execution and deliberate attempt to conceal the crime. Both as adults. We reached out to their legal representation. One declined to comment, and the other said in part, quote, "I cannot speak to this particular case, but before clarity," adding that the family of their client conveyed empathy to the family of Nohema Graber. In a statement, Fairfield Community School District Superintendent said that, quote, "In her 9 years with Fairfield High School, Mrs. Graber touched the lives of many students, parents, and staff. As a community, we will remain united in this time of tragedy." That community has put Graber on her on
and shared some really powerful words on Facebook, specifically about the student peace in lives. There was angel of a woman for counseling during this difficult time, Allison.
Thank you for that. We appreciate it. Isa Gutierrez.
What did you guys think of that so far? I have a few more videos. I was going to do the hearing, but I may have to do this in 2 parts, seeing as I was having some issues. But we will do this.
Their
That
mental
was like Spanish 2 or 3 class. She was we had
by his middle name, Chaden.
having known Shaden, having him in my math class. It's
Here had trauma. For her students, those details are unthinkable.
She was really, she always perfect.
I just want to make sure you guys are able to hear the video. Have you been able to hear the video? Thank you. I'm still getting used to things, but are you able to hear the video is my main question. You're awesome, Punksy.
Came to check on
There is going to be a vigil for the teacher, and for more on that, let's throw it over to Kayla.
And to write messages for Nohema Graber, who seems to be they have and like don't have just want to come together at a time of group and speak to two of the parents. They tell me they're doing this for their children who came home this week heartbroken.
One, that this is not okay, and two, we will stand as a community.
An hour at 7 will be here throughout the night. And
So is the video choppy or am I choppy when I talk? I'm just curious. Oh, okay. Yeah, this laptop I've had for a minute. So, like, it's been a minute. I'll show a few more videos. I was going to, like I said, I was going to do the hearing that they had, because the case is very close to where I live. It's not far, and they're going to be moving it to Davenport, Iowa for one of the boys. So I will definitely be live streaming the trial for that, which is coming up, I believe, next month. So hold on one second. Dang it. Hold on. Hold on.
Social media. They are accused of plotting a is live Roger Dicking.
Imagine people clear with the could not be this happen. Facing charges for alleged role teacher Graber, a Spanish high school, missing on Wednesday. Her body was in Fairfield.
Children of this community that went to discuss
Fairfield, known as a peaceful place. A number of years ago, a transcendent peace and harmony. That's what Field is. Quiet. Miss one.
So it was just, the place where we be, the community, everybody, wonderful, the world, bringing our children up with the ideals that we have.
Well, tonight here,
Our thoughts certainly go out. Fred and below.
Yeah, that is weird. I wonder if it's just I need to let the videos load a bit more. I don't know. I'm still new to this. It's just, this case is strange because these two boys killed their teacher, planned it, all because of bad grades, which is Wow. Now, they were 16 at the time, and because of it was such a planned and vicious murder, these two boys are being tried as adults. Which says a lot. So here's another video. So 1 second.
In 2021 is asking to push back his murder trial. Both Willard and Nohema Graber, prosecutors say they beat her to death at a Fairfield park. Her body was found 1 day later. In March, his lawyer had a busy schedule and needs more time to consult expert witnesses and review documents.
Yeah. Okay. So that's how I'm going to do it for right now. I will get to the next video. It's such a strange, I don't know. I mean, it's weird because in this one, we know the motive. I just can't wait to get to the trial so that way I can see, I don't know. I want to be able to see what happens. And
for nearly a year, many Iowans have wondered since Nohema Graber was reported missing. Police found her body the same day in a park.
It's also the day two teenagers were November 2nd of 2021.
Stephen.
I just want to let it load just for a second.
Based charges in Graber's death. Both were 6 account yet of that day. Because they saw 2 males driving Graber's van near Chautauqua Park, where Graber was later found.
Nicole, the boys were 16 at the time. One of them was really upset because there was some grades that affected his GPA. And he didn't like her, apparently. So one choice got into all this mess.
One judge to throw us still tomorrow's here. It's at 1:30.
Degrees have been separated. Both were given a change of venue. They were initially going to be tried in Fairfield, town in South Otomi County, outside of the state. Goodale's trial is scheduled to start December 5th in Scott County in far eastern Iowa. If convicted, both face life in
Okay. I am going to switch to watching the first half of the hearing, and I'll do the second half of the hearing tomorrow, now that I know what to do and what works. So give me 2 seconds. But I just hope everybody is doing okay. I'm just going to chat a bit until that loads. So, yeah. But yes, these boys are 16 years old. Well, they were 16 at the time. I think they're like 18, 18, 19 now. But yes, for their crimes, they are being charged as adults because the crime was that vicious. I mean, they hit her with a baseball bat and took pictures and recorded themselves on Snapchat, which is what gave it away. And then they buried her underneath a wheelbarrow and a tarp and some railroad ties, which is horrible. Absolutely horrible. And I mean, there's only so much that can be said for that. So I am going to go ahead and back. And due to timing and everything, trial for one of them is going to be the end of this month, beginning of, I don't think it will happen, or not happen. I don't think it'll be a long trial. Definitely won't be as long as Murdaugh's. So that's for sure. Let me see here. Sorry, I have been having technical issue after technical issue today.
Yes, Your Honor.
You ready, counsel? The Iowa District Court for Jefferson County. We are here on case FEC 005143, State of Iowa versus Willard Miller. We're here today for a motion for Frank's hearing and a suppression motion of the defense. Present hearing is the defendant, Miller attorney Nathan Olson. Also present is the state of Iowa, represented by Jefferson County Attorney Chauncey Molding and Assistant Iowa Attorney General Scott Brown. Counsel, it's my understanding that the parties wish to address the application or motion for Frank's hearing first and then
Yes, Your Honor.
Okay, well, I'll turn it over to you then, Mr. Wilson.
Thank you, Your Honor. As a preliminary matter, as discussed in chambers, there are of exhibits that have been filed under seal with court permission that we would ask, or that we would offer this time. Those are exhibits A through V, as in Victor. Those were filed with the court in March of this year. Additionally, as exhibits that will be filed under seal with court permission are exhibits Triple H, Triple I, and Triple J, which are each transcripts of depositions. Triple K, which is an audio exhibit and provided to the court and to opposing counsel. Exhibit Triple L and exhibits Triple M and Triple N, the last two being video under seal and provided to this court.
Your Honor, the state would stipulate to the admission of those exhibits listed defense exhibits has what I have labeled as state one, although I'm certainly willing to change that designation. A paper copy of 4 search warrants executed in this proceeding, as well as what I've listed as Exhibit 2, which is a thumb drive that is provided to law enforcement by Jay. Additionally, to offer video and following this proceeding. I will label that State's Exhibit 3.
And any objection to the exhibits, Mr. Olson?
As long as those exhibits are filed or sealed, no objection to those exhibits.
State does not object to filing those 3 exhibits under seal.
So State 2 and 3 will be admitted, and I'll allow electronic at a later time. But for now, I will admit defense exhibits V. And then if there's no objection to the triple H, triple I, triple J, triple L, triple M, and triple N, I will have objection as well. Unless, counsel, did you want to read those?
I'm relying on a statement of defense that those are the attested to deposition transcripts, and assuming that those are what they're purported to be, I think that those are appropriate consideration. What happened? Could we jump from single to triple?
Mr. Molding, we have a number of proposed exhibits in the waiver hearing, so we burned through a lot of the potential exhibits there.
Okay, Mr. Olson, you may go ahead and proceed with the motion for Frank's hearing, whatever you'd like to supplement your motion with that you filed already.
Thank you, Your Honor. Obviously, this court has the motion, which has been filed under seal. Obviously, it discusses matters that are protected by Iowa Code and other rules of criminal procedure. Hence, the necessity of those being. I'm not going to discuss the specifics of the evidence. Generally, point out that specific regarding the information we're saying that was known for time before search warrant applications were presented to a judge. Information identified weighs heavily on a finding of probable cause. And those 4 search warrant applications someone involved. The reason we filed this Frank's motion is because enforcement has to provide under Iowa law that they should when deciding whether or not a search warrant application is supported by probable cause. Much information was not provided that should have been told. There were individuals providing information to law enforcement that the magistrate was never told about and was never allowed to determine whether or not that individual source law. As discussed, I will be much more specific in the filing following this hearing and talk through the specific exhibits and why those support the motion for the preliminary finding. It's our position that the exhibits provided to the court previously and that have been offered today show at least a reckless disregard on or was mistakenly put in that search warrant application. And as this court whether or not that's up to the court, but we have at least passed that threshold, a reckless inclusion and omission such that a full Frank's hearing should be granted by this court. Thank you, Your Honor.
Thank you, Mr. Olson. Mr. Mullen.
Your Honor. For Frank's hearing filed by the state on October 31st. It has not met its preliminary burden to establish a preliminary showing that any falsehood or false swearing or a reckless disregard took place in the deputy's swearing to the search warrants that resulted in the search of the defendant's home and person, the search of his cell phone and computer, the search of his Snapchat records, and the warrant for the cell tower records. Specifically, and this affidavit it's short enough that I'm going to read the whole thing here. However, paragraph 3 of the warrants is the principal showing that I think that is in controversy here.
The state is attempting to read into the record information that has been sealed and that has been identified as private.
Can you identify what you're looking at?
Your Honor, I'm
What
reading
exhibit?
the affidavit in defendant alleges is a false swearing by a law enforcement officer. I'm prepared to present that document that is in question in controversy and point to the court a number of points where the allegation of essentially perjury by an officer, a very serious allegation, is disputed by the evidence.
I just was curious if you could tell me of the exhibits that we've admitted, which one you're looking at.
This would be, well, from the states, it states it's the sworn affidavit to search warrant for Chaden Miller's.
And do we think maybe Mr. Olson knows if that's exhibit a G or a D, maybe? Are you familiar with what Mr. Molding is looking at?
Your Honor, the offered exhibits that were filed under seal contain each search warrant application and each search. So if sure, but we have 4 search warrant applications that issue, 4 of them proposed exhibits, and all 4 of them contain what I believe to be the operative language that is in public record.
Judge, these search warrants, you have to get into the record and discuss this in open court. I don't understand where the controversy is.
It was
that state that Jeremy and Willard Miller related to the death the defense hangs its hat on and its allegation of false swearing.
Okay, I am going to let it load up just a few minutes and talk. There was some stuff that came out during this hearing about things that didn't go the way that they were supposed to go via law enforcement and investigators. So, yeah, we will see.
Juvenile J, conducted by Special Agent Kelly for
Just fixing something really quick, so hold on.
good evidence on Ms. Graber, detailed the manner in which she was killed, where her body was located, where the vehicle was disposed of, things its hat on, and its allegation of false swearing by the law communication, which had been corroborated by officers. This was the court's attention. The audio of the juvenile investigation Kedley for the Iowa Division of Criminal Investigation, specifically to timestamp 2 minutes, 13 seconds. Jay states specifically, quote, "It wasn't just Jeremy, it was 2 people." To timestamp 4 minutes, where the special agent asks if Jeremy did it by himself, and answers when the juvenile Jay states his best friend Shaden, meaning Jeremy Goodale.
Again, same objection as before, where he is reading the
argue rights application.
Your Honor, the discussion that we had is from the public until it's determined whether they should be suppressed. The state gets to read into the record the exhibits that the seal. That is on right to a trial because it puts information out into the otherwise.
Just trying to have his cake and eat it too. But when I'm pointing the court in the direction of allegations, the court shouldn't look at it.
Well, it's the objection is overruled. There's no reason to read through the court application because I've read it. I'm a motion hearing. Proof to prove officer was lying or purposefully we have to get out. So, Mr. Molding, I'll ask you to on the subject of whether law enforcement was reckless, recklessly disregarded the truth, or purposefully deceitful.
Your Honor, may her very briefly.
Yeah.
I would ask that whenever possible, this court and general specific of the statements made. This court is going to have the audio that the state is referencing, and this court will be able to determine without state's interpretation or my interpretation on behalf of Mr. Miller's whether or not it was reckless or purposely truthful. The timestamp identification in a general statement should be sufficient for this court to understand. I would ask that the court direct on that regard.
And I believe I did. So, Mr. Molding, what I told you, you can proceed.
Thank you, Your Honor. Additionally, JB, along with his girlfriend, Kay, the question, I think, was raised causal nexus between the evidence that's presented by
Okay, I am going to let it load for a couple of minutes, and I'm just going to chat. This, what I did in the beginning, just as a refresh. This is the Spanish teacher murder. Her name was Nohema Graber. She was 66. and had been a Spanish teacher at Fairfield High School in Fairfield, Iowa since 2012. According to the school's website, to know Nohema was to love her. She was the kind of person every community longs to have in its midst. And we are blessed to have her in our lives. She was born in Veracruz, Mexico on November 10th, 1954. She was a flight attendant who also became a pilot. All of this in Mexico. I believe she was one of the first female pilots in Mexico. She then fell in love and moved to her husband's hometown in Fairfield, Iowa. What happened was on November 2nd, 2021, two Fairfield High School students, Willard Miller and Jeremy Goodale, were upset over a grade because they got a bad grade and one of them, their GPA was going down and they were upset. On that day, Graber left the school around 4 p.m., headed to the Chautauqua Park, where she normally went after the school day ended for her daily walks. About an hour later, witnesses reported seeing her van leaving the park with Goodale and Miller in the front seat. On November 3rd, law enforcement identified Miller and Goodale as suspects after a witness alerted police to social media messages pertaining to Graber's death. Goodale allegedly bragged about the murder to a friend on Snapchat. Her body was found later that day. The body of Nohema Graber was found hidden under a tarp, wheelbarrow, and railroad ties at the Chautauqua Park in Fairfield, Iowa. I cannot say that word to save my life right now. She had been beaten to death with a baseball bat. Miller and Goodale were 16 years old at the time. Goodale described in the messages how the pair had conducted surveillance on Graber and described how they unalived her and dumped the body. According to the search warrant included in the messages was that a baseball bat was used to unalive Graber. Court documents said the teacher suffered trauma to the head. The documents say a witness told police the items used or worn during the crime were taken to Goodale's home. And this is the hearing of Willard Miller. Now, his trial is coming up. I know one of the two boys is going to be in Scott County, Iowa, in Davenport, which is relatively close to where I am, which is why I wanted to cover this case because it's not very widely known. Okay, Karen Canada. Thank you. So I'm going to get back to the rest of the hearing. Why do I keep doing that? Hold on.
Spilling over into suppression issues, but essentially an office truth when stating in his search warrant that Chaden Miller was implicated in the homicide of Nohema Graber during the interview. Girlfriend, the two-court record. Additional general statements from that interview JB states with specificity that they, the court, pointing to Chaden Miller in the first few minutes of the conversation, he refers to the they in that entire audio interview is Chaden Miller and Jeremy Goodale. Every time JB and K indicate they're indicating Chaden Miller. Good. JB states that they took her car, that they, or K indicate, JB's girlfriend Kate states that they, quote, took $75 from her wallet. K ditched the car and was borne out by Long's investigation. And K indicates that the defendant believed in it. And finally, at timestamp 11:20, John asks if he's talking about Goodale, asks if Mr. Goodale was with Chaden during these incidents, and John states yes. More than his thumb drive. I believe it's clear in the testimony the court's in front of it that the documentation of that Snapchat communication was done but not complete. There are missed portions of those communications. The deposition transcripts indicate that Mr. Miller's name came up during the Snapchat conversations. Your Honor, I think that the motion for a hearing fails on a number of grounds, particularly that the evidence that was by law enforcement both before and after Chaden's execution of the search warrant bears out that search warrant. I think defense counsel is misquoting the obligation parties here. And obviously, a magistrate or in this case, the district court judge that the search warrant consider any number of things, but it's not the law. It's a misstatement of the law that all information needs to be presented to a magistrate when considering a application for a search warrant. I would draw the court's attention to paragraph 12 of the state's exculpatory and exculpatory evidence, regard for the truth, or a misstatement. If the officer doesn't present the interpretation, all that needs to be presented to the court is probable crime committed and the search and the things to be seized. State would and not even a reckless disregard for the truth, as borne out by
Your Honor, as we set out in our motion, took information from.
Okay. They are requesting a separate hearing because they feel that there were some things that law enforcement did wrong, and they're going to have one of the parents testify here in a bit. And that will explain things a little bit more.
That paragraph, there, and it's very clear, as stated out in our mo- shows that this
And any objection to
State does not object to filing those three exhibits under seal.
so stage 1, 2, and 3 will be electronic, but defense exhibits A through V. And I will admit those without objection as well. Unless, counsel, did you want time to review?
I know that would be, I think that those are appropriate for consideration. I'm a little confused. What happened to the double letter? Could we just jump into
the number of different burns for a lot of potential exhibits there.
Indeed, whatever you'd like to supplement your motion with that you filed already.
Thank you, Your Honor. Obviously, this court has the motion, which has been filed under seal. Obviously, it discusses matters by Iowa Code and Iowa Rules of Criminal Procedure. Hence, the necessity of the discuss the specifics of that specific time, the 4 search warrant applications were presented to a judge. By that motion and statement that application that identify my client as someone involved. The reason enforcement has to provide under Iowa law all information that they know or should know, issuing, stating whether a search warrant application is supported by probable cause. Much as that should have been told, there were individuals providing information that never allowed to determine whether or not that individual should be found credible as a source of information by law enforcement. As discussed, I will be much more specific in the filing following this hearing and talk through the specifics and what the finding. It's our position that the exhibits provided to court previously and that have been offered today show at least a reckless disregard. As this court is well aware, the standard is either recklessly provided or a purposeful misstatement or omission. Whether or not it was purposeful, that is up to the court, but we have at least passed that initial threshold of reckless exclusion and omission such that full should be granted by this court. Thank you, Your Honor.
Thank you, Mr. Olson. Mr. Mullen.
Your Honor. First off, the state would stand for October 31st. The defense has not, it's preliminary showing that any falsehood or false swearing, a reckless in the deputy swearing to the home in person, for the search of his phone and computer, the search of his Snapchat records, and the warrant for the cell tower records. Specifically, this affidavit it's short enough that it can be, I'm not going to get the whole thing, however, paragraph 3 of the relevant warrants is the principal showing that I think that is in controversy here. On November 3rd.
Your Honor, I object. The state is attempting.
Can you identify what you're looking at?
Your Honor, I'm
what
reading
exhibit?
Paragraph 3 of the affidavit in question. The defendant is a false law enforcement officer. I'm prepared to present that document that is in question in controversy and point to the court point.
I just was curious if you could tell me of the that we've been looking at.
Well, from the states, it states Exhibit 1. It is the sworn affidavit to search warrant for Chaden Miller's home.
And do we think maybe Mr. Olson knows if that's Exhibit G or maybe D? Maybe. Are you familiar with what Mr. Lisle?
Your Honor, the offered exhibits that were filed seal searching of which specific exhibit, but for search warrant application and all that the state is attempting to read into the public record.
Judge, I don't understand where the controversy is. This and that involving an interview with
whether the officer provided with you can just keep that as a narrow focus.
Sure. My attestation of 41 November 3rd. An associate of the defendant showed that officer messages that Jeremy and Miller were involved in planning, executing, disposing of evidence related to the death of Nohema Graber. The information outlines a conversation Mr. Miller conducted surveillance on Ms. Graber, detailed the manner in which she was killed, where her body was located, where the vehicle was located, and how evidence of the crime was disposed of. This is the principal I believe the defense on his allegation of false swearing by the law enforcement officer. It was also communicated to the body and corroborated by officers. This individual came in after Mrs. Graber's body was located. I would draw the court's attention to the audio of the interview with Juvenile J, Dr. Kedley from the Iowa Division of Criminal Investigation, specifically to timestamp 2 minutes, 13 seconds, where J states specifically, quote, "It wasn't just Jeremy, it was 2 people." To timestamp 4 minutes, where if he did by himself, and the Juvenile J answers no. When the special agent asks who was the J, states his best friend, Shaven, meaning Jeremy.
The application for a Frank's hearing, if you can't argue the Frank's application.
The discussion that getting she recently sealed these about is to keep them from the public until it's determined whether this court say that the state gets the right to seal severely on my client's right to a fair trial, because
Your Honor, defense counsel is trying to have his cake and that my officer swore pointing direction up into that swearing. He's saying that the court shouldn't look at.
The objection is overall reason to read through the search warrant application, because I know it's for Frank's hearing. Proof line or disregard for truth. We have a public hearing, which is a public hearing. That's just, I'll ask you to keep your purposefully deceitful.
That whenever possible, this court could order the state and this court will be able to determine dates and Mr. Miller, applications should be sufficient for this court to understand. I would ask that the court
be along with his girlfriend Kay. The question I think that there is by well issues stating in his warrant that
Okay, I am gonna go ahead and end it right now. I will do another live tomorrow. And I'll do a very quick recap and then I'll restart the hearing. Now that I have all the technical difficulties out of the way. But I hope everybody enjoyed my live. And if you're part of the replay crew, definitely let me know. So we will go to my outro and that will be it.